My name is Joe Stagg. I'm speaking on behalf of my developmentally disabled son, Larry Flippo, presently in the Weld County Jail for violation of probation. In 2002, at my son's first conviction, he was found not guilty of force and guilty of sexual assault. He was sentenced 8 years to life at the Department of Corrections and was not classified a sexually violent predator, commonly referred to as an S.V.P. After 2 reversals of conviction, he was granted a new retrial. He was convicted a second time on November 20th of 2009. At his sentencing on January 21st of 2010, after 8.5+ years of incarceration, he was classified a sexually violent predator by both the Weld County probation officers and the judge. Same charge, same incident, 8.5+ years of incarceration, and poof, he's now classified a sexual violent predator. He was given 10 years probation, 10 years life probation, and placed in a 24-hour supervised setting. The complete impact of this label and classification was not fully realized until my son was refused outpatient sex offender treatment by 3 different sex offender treatment providers, all chosen and influenced by the probation officers. Because of his inability to find a sex offender treatment probation, on February 25th, 2010, he was returned to jail for violation of probation through no fault of his own. There is a determination process consisting of evaluations, an S.V.P assessment screening instrument, and guidelines commonly referred to as the standards set by the Sex Offender Management Board, commonly referred to as S.V.P. S.V.P is responsible for the guidelines and sex offender treatment providers, but not responsible for how the guidelines are enforced or interpreted. They have told me that it's the Attorney General's office who okays the standards, and the Division of Criminal Justice is responsible for the enforcement of the standards. Said process determination screening instrument is prepared and decided by both an evaluator and a probation officer. They determine if the defendant is remorseful, considered a high risk, the level of denial for the defendant, and if the defendant is amenable to treatment. In my opinion, all 4 items can be manipulated by an evaluator and/or probation officer with a personal agenda. If a probation officer's main goal is to send a defendant to prison, this screening process can be made to fit as to determine a person a sexual violent predator. The standards don't address this issue. Probation officers, in my opinion, are given too much power for this decision and can abuse such power. The pre-sentencing investigation, commonly referred to as a PSI, is prepared by the probation officer and assists in this determination also. My son's PSI is riddled with errors, false statements, convictions, and contradictions. The probation department makes the recommendation and the sentencing judge makes the final S.V.P determination and enters the S.V.P order on record. In my son's case, he wasn't remorseful enough to satisfy the probation department, and probation has decided he's at a level 3 denial, which is the most severe denial level, which to all of those that know him, this is not an accurate assessment, and per the standards, immediately prohibits a defendant from community-based outpatient treatment. And probation would have you believe that he doesn't want treatment, which also isn't an accurate assessment. Larry wants treatment, but does need sex offender treatment specifically from a provider with developmentally disabled expertise. He will not receive this type of treatment at the Department of Corrections. Colorado is one of the few states to have a sex offender management board. The legislative mandate of the S.V.P and the primary goals of the standards are to improve community safety and protect the victims. We want our community safe. However, the standards are vague, and in a lot of areas, they give too much power to the probation departments and officers. I contend this power can be abused, and that S.V.P is aware of this, but not too concerned with it. To add insult to injury, Governor Ritter recently vetoed an amendment to House Bill 1374, introduced and approved on the floor by Senator Foster. The bill asked for the SOMBI to allow a sex offender to choose their sex offender treatment provider. In my son's case, the probation officer stated she was the one to choose the provider, and in my opinion, influenced their decision not to provide treatment to my son. The approved bill would have cleared this issue. Too much power is given to probation. Our goal as the advocates for justice and empathy for the developmentally disabled is to educate the public and improve and change legislation. We ask for the support of our senators and representatives. I'm asking your help in calling and emailing the senators and representatives, but you could also help by contacting us at this website, www.letmetakeyourpics.com. Our photographer has offered her website, and there's a special tab there that for advocates for justice.